it's Tara Lucke here. I had a question come through the Art of Estate Planning Facebook group a while ago about whether it's possible to set up a testamentary trust post-death. So we're talking about a testamentary trust that's not included in the will when a person dies. The answer is yes, but they are inferior on every test. So don't rely on them. Do a testamentary trust upfront in the will. So these types of testamentary trusts set up after somebody dies are often called post-death testamentary trust or an estate proceeds trust. So there's an ability under section 102 A G of the Tax Act to contribute assets that were inherited into a trust environment within 3 years from the date that the person leaving the inheritance died, and you can then get accepted trust income treatment on the amounts contributed. So accepted trust income treatment, as a reminder, is basically the rules where minors can be taxed on income earned by the trust at adult marginal rates. Okay, so they don't pay the penalty tax. The amount that you can access accepted trust income for in a post-death trust is only the amount that would have been received on intestacy by those beneficiaries of the trust. So depending on which state you're in, that can be very limiting in terms of the options. If you're in Queensland, it does work in a narrow range of circumstances. So let's look at, we've got a couple, husband and wife, and they've got 2 children. So in Queensland, under the intestacy rules, the first 150 grand goes to the spouse, and then the rest of the assets in the estate would be split between the spouse and the 2 children equally. So in this case, after the 150,000, 2/3 of everything else could be contributed into a post-death testamentary trust, and you could then stream the income on that 2/3 to the children at adult marginal rates for tax purposes. So that could be useful because our surviving husband, if he has actually in fact received everything under a will, so that you'd usually use it where the will is a basic will and the wife just left everything to the husband. Perhaps he's got some asset protection concerns on a higher income already, you could use a post-death trust in that case to have, you know, the 2/3 of the inheritance after the 150,000 in a tax effective environment. If you're in a state like New South Wales, on intestacy, everything goes to the surviving spouse in that situation. So you actually have got no amount that you can contribute into a post-death trust that's eligible for accepted trust income. So the strategy just wouldn't work. Also, it's difficult if you've got like grandchildren. You can't use this strategy because grandchildren are rarely going to be able to receive it on intestacy unless we sort of work through all those provisions. So that's your first problem with a post-death trust, is that it really only has a very narrow range of circumstances where you get the tax treatment as accepted as accepted trust income, because of the overlay of the intestacy rules. Where you've got the testamentary trust set up in a person's will, it doesn't matter. You can have accepted trust income to everybody who's eligible, and that's generation upon generation upon generation. With the post-death trust, 1 generation. The other thing is that they're really not very great for asset protection because the beneficiaries who are getting the tax treatment have to be absolutely entitled. So they have to have capital rights to that asset, rather than a testamentary trust set up in a will. You know, the capital is just totally discretionary. So they're not as useful for asset protection on family law or bankruptcy. The other thing is that you can only really contribute assets that don't have big capital gains tax or stamp duty costs associated with them, because there's no exemption to contribute to a post-death trust. So any assets that are distributed under a will, there's CGT and stamp duty exemptions, but post-death trust contributions are made after the estate administration. They're not pursuant to a will, so you're not going to get any exemptions. So you're really restricted on the types of assets you can put into them as well. My assessment, if you have a client who has not used a testamentary trust and there could be some benefit of a post-death trust, ask the question. I'm very happy to do an analysis for you to work out whether it could be useful. In my experience, there's only a very narrow range of circumstances where it works. So don't rely on the idea that you can use a post-death trust as a backup, because on every test they are inferior and a lot of the time they're not even useful. So get the testamentary trust set up in the will proactively. They're my favorite estate planning tool. They're so powerful. You really only get one shot. It's very hard to reverse engineer those outcomes. So that's it for me for today. If you've got any questions, as always, please feel free to get in touch. Have a great day.